Good afternoon. I'm Ricky Polston, the Chief Justice of the Florida Supreme Court, and we're here today to honor Justice Ben F. Overton for his judicial service, for the great work he's done on behalf of the state of Florida, and to honor him and his memory and the work he has done. We're going to have some speeches or some comments today from Sandy D'Alembert, Justice McDonald, and Governor Askew. And I would first like to recognize members of the family who are here with us today. We appreciate their being here, and distinguished guests who are too many to actually name. Staff lawyers of Justice Overton who served in this court, and students that he has taught in law school, please stand. Thank you for being here. You may be seated. I had the great pleasure of getting to know Justice Overton, actually not when he was on the bench, but afterwards, after he retired. And I had the honor of entering an administrative order on July 26th, which was the continuation of his being a senior justice of the court. In 1999, when he retired, ever since then, continuously, he was a senior justice of the Florida Supreme Court. And I have his letter here that he had sent back earlier this past year on February 23rd, applying for that, and the court unanimously approved that, and I entered the administrative order on July 26th. Justice Overton regularly taught at the University of Florida, as many of you well know. He taught Florida constitutional law and would bring his class to the court to listen to oral arguments every year. Just 3 months ago, in October, he was here with his class listening to oral arguments, and then at the noon hour, he would bring the class not to talk about the cases that were argued, but to talk about the papers that were being written by them in their class. And they would talk about the different issues that they were addressing. And I saw Justice Overton's eyes just light up. He was so engaged about the legal issues that they were discussing. He loved teaching. He loved discussing the law. He would pull me aside at the District Court of Appeal conferences and different educational events and talk to me about the governance of the branch. He was very engaged into what was going on with the governance issues that were before the court, not particular cases, but just legal issues. He loved the law, and he loved talking about it. So I had great conversations with Justice Overton, and I will miss him, and this branch will miss him. So it's only fitting that we honor him in this court, a court that he loved, and that's what we're going to do today. We're going to have Sandy D'Alembert address us. Sandy D'Alembert was a dean of the law school, president of FSU University, and president of the ABA.
Mr. Chief Justice, thank you so very much. I believe that over the years, this has been a very well-respected court. Think of Justices Terrell, Westcott, Whitfield, and in more recent times, Irvin, Drew, Thornall, and Thomas. But if we're going to tell the story about Ben Overton's impact, we have to concede that there was a period of time that was documented quite well in newspapers and books when this court was not held in high esteem. And if we're going to tell that story about the awful conduct that took place by some members of this court, we have to remember that this conduct had to be addressed, dealt with, and the court had to be brought back to the position it is in today. Now, Ben Overton contributed many things. I'll talk about a few of them. But for the lawyers and judges in this courtroom, the thing that he did that was so important to us was he was the justice who saved the court. And that's the theme of what I'd like to say today. Ben came to the court from distinguished service as a trial judge in Pinellas County, a role that one of his sons has followed. When Janet Reno served as staff director for the House Judiciary Committee, she and the legislators she was working with decided they ought to look around the state and find some place where the trial court system really worked well. And so she looked at all the objective data. It was the Sixth Circuit. It was Pinellas County and Pasco County. And that was incredible because that circuit had just been through a terrible, terrible problem of its own. It had had a chief judge who had been accused of abusive conduct to lawyers and litigants, and we had an impeachment proceeding out of the Sixth Circuit. So Janet Reno went to Pinellas County to meet the new chief judge named Ben Overton. And when she came back from that trip and she gave a report, she said, "This is a phenomenal set of trial judges. They all like one another. They get along. They're productive. They play tennis together. They play softball. They're engaged in a number of activities together. It's a collegial court, and it really operates." So Janet asked, "What should the legislature do to replicate this?" And Janet said quickly, "Find 20 chief judges as good as Ben Overton." But since that's not possible, you at least should know that Ben Overton is the chair-elect of the Conference of Circuit Judges, and he believes that there ought to be judicial reform. And at that point, or shortly after that, Ben Overton became an unpaid consultant to the Florida House Judiciary Committee. He saw every draft that was done in Article 5. He consulted closely, and the Article 5 was really designed around what Ben Overton thought was necessary to make a trial court work. With Article 5, the court got a lot of the tools that it needed and still uses to manage the court system. Good rulemaking power, designation of the Chief Justice as the person who really speaks for the court, control from the Supreme Court down to the chief judges of the district courts and the trial courts. It was a good system. Consolidation of the trial courts, a good system. It got in place, and everybody was optimistic that all of a sudden we would have really important changes in our system. But the question was, is the Florida Supreme Court in a place where it can provide the leadership? And at just this time, with the passage of Article 5, just after that, a series of news reports came out from television and newspapers about problems on the Florida Supreme Court. I don't think we have to review those problems in detail, but we should say in conclusion that the court was no longer a highly regarded court at this period of time in the mid-1970s. When the court went through this crisis, it was very lucky to have a governor who cared about the judicial system. Governor Askew had issued an executive order which actually replaced his own unbridled power to make judicial appointments, and he established a merit selection system. When the resignations coming out of this crisis began to hit, Governor Askew had the authority to make the appointments, and he did them through the merit selection process. And the first of these came available. There was an unusual amount of interest, in part of because the system itself was so novel, and partly because everyone knew that it was important to get new leadership on the Supreme Court. Governor Askew appointed Ben Overton after he had been nominated by the merit selection process, and he could not have made a better choice. The importance of having someone on the court who was not associated with the earlier misconduct soon became apparent. When impeachment proceedings were instituted against Justice McCain, those prosecuting McCain decided that if there were to be a Senate trial, the most senior justice who could preside at that Senate impeachment trial was Justice Overton, who had never voted with Justice McCain on any of the cases that were the subject of the impeachment charges. Now, Justice Overton is important to us not just because he avoided corruption and would not tolerate it. He's important to us for many reasons, and I'm going to mention just several. Legal services, privacy, dispute resolution, something about his dissents, and something about his teaching, which Chief Justice has already alluded to, and which meant a great deal to him. Legal services. Florida's Constitution guarantees access to justice, but anybody who's acquainted with the system knows that for poor people and many middle-class people, we simply do not have that access because legal services are not available. Justice Overton wrote an opinion in 1980 that began a series of opinions he wrote on legal services. Well, the 1980 opinion dealt with the right to representation in juvenile dependency proceedings, but he authored many other decisions in this same area. In a 1990 opinion, he set the predicate for Florida's historic rule requiring mandatory reporting of pro bono services. And he said, "We hold that every lawyer of this state who is a member of the Florida Bar has an obligation to represent the poor when called upon by the courts, and that each lawyer has agreed to that commitment when admitted to practice law in this state. Pro bono is a part of a lawyer's public responsibility as an officer of the court." In my opinion, no other justice has contributed more to the pioneering work that this court has done to enhance legal services for the poor. Privacy. I think most of you look at the Florida Constitution and see things there that are novel, that are not in the federal Constitution, and the right of privacy, the freestanding right of privacy, is one of those things. Several people in the audience served with Justice Overton in the 1977-78 Constitution revision process, and they'll remember that Justice Overton spoke at the organization of that session, of that commission, and suggested a freestanding right of privacy be incorporated in the Florida Constitution. It was done, it was offered. The whole package was rejected, but the provision on right of privacy was picked up and offered by the Senate. Senator Dempsey Barron and Professor Pat Dorr revived this proposal and got it considered at the 1980 election. It was adopted in the 1980 election by an overwhelming vote. And then following that, there was a series of cases testing the right of privacy. One of those cases was brought by Senator Dempsey Barron, who Justice Overton really admired in many ways, appreciated what Dempsey had done to resurrect the right of privacy. And so Dempsey soon was involved in a divorce action, and he asserted the constitutional right of privacy to avoid discovery in his divorce action. Well, this court rejected that idea, and who do you think wrote the opinion? Justice Overton. As you look at Justice Overton, you saw a judge who cared about the principles of law that he was dealing with. It was not relating to personal relationships in any way at all. A word about dispute resolution. When the modern movement for dispute resolution began, Florida took an early lead among all states, and this came about because it was Justice Overton who saw the possibility of alternative dispute resolution, and he sponsored rules for the Florida Bar that allowed dispute resolution to bloom in Florida. His work was recognized nationally, and he was elected as the chair of the American Bar Association section on dispute resolution. Now, Justice Overton did not dissent all that often. He was not known as a great dissenter of the court. That title probably belongs to Parker Lee McDonald or to Justice Overton. I'm not sure which one won that competition, but Justice Overton usually agreed with his colleagues, but when he disagreed, there were interesting opinions. He rendered an opinion in the term limits case, pointing out that the term limits proposal was flawed. It called for term limits for both state officials and federal officials could not be limited by the state constitution. But although he was later vindicated by a subsequent United States Court, Supreme Court decision, that we are stuck with term limits. Another area where Ben dissented was really interesting, because you remember that during his practice he had represented what was in those quaint and distant times called the St. Petersburg Times. Now, you would think that Justice Overton would be an easy vote for First Amendment issues, but if you look at the record, you find that when a circuit judge from Orlando was accused of speaking out and questioning the application of the death penalty in Florida, 6 justices of the Florida Supreme Court said that Judge Gridley had the right to do this. One justice dissented, Justice Overton. Justice Overton, it was the judicial system that made most difference. That always trumped everything in his mind. He also had an interesting case that came before the court relating to a young lady who's in this courtroom, and she had been convicted of contempt of court for revealing grand jury secrets. When her case came before the court, again, there were 6 votes to overturn that conviction, and 1 dissent, Ben Overton. St. Petersburg Times reporter, did not make any difference to him. It was a justice system that made all the difference to him. I wanted to say a word about teaching, because Chief Justice is absolutely right. Justice Overton just beamed when he was with students and dealt with students, and they liked him as well. He was obviously made a great reputation for himself as a judge, but also as a teacher. He taught at Stetson before he came on the court. When he came on the court, he taught at Florida State University Law School, and then finally at his beloved University of Florida. He also collaborated with Professor Chuck Earhart and Supreme Court Justice John Paul Stevens to offer an Oxford program of study for trial judges, a program that was co-sponsored by the National Judicial College, where Ben was very active. When I heard that Ben had made sure that his papers were graded before he went into surgery, I was very amused. Many law professors I know would say if they're going into surgery, if something goes wrong, at least I don't have to grade those damn papers. But Ben did this not out of a sense of duty. It was out of the sense that Chief Justice described. He cared about the students. He wanted to read those papers. He would often take the papers that students would provide to him and send them around to other lawyers in the state and judges in the state, because he wanted them to see what his students were doing. He really cared about the students, and it's not surprising at all that he took that position. After Ben's appointment, this court, which had been known as the Court of Roberts and McCain, became the Court of Overton and those who served with him. The Court of Overton, England, Sundberg, and Hatchett. The Court of Carl, Alderman, McDonald, Ehrlich, Shaw, and Barquette. The Court of Grimes and Cogan, Harding, Wells, Anstead, and Perriente. The Court of those who served with him, and all of you who have followed him. We owe this magnificent change to Governor Askew, who changed the system of selection and appointed Ben Overton, who then redeemed the promise of a just system, changed the culture of the court, and reestablished the Florida Supreme Court as one of the most distinguished in the nation. Ben Overton is a justice who saved the court. It's my great pleasure now to introduce a great colleague of his, a person who followed him as chair of the Conference of Circuit Judges and later followed him on the court, Parker Lee McDonald, Again, may not hold the record for the most dissents. I'm not sure of that. But for lawyers who practiced before him, he was always a justice very much like Justice Overton, who had come up from the trial court and who knew the record so very well that lawyers who appeared before him had better be very careful not to make a misstatement, because they would find that Justice McDonald was correcting them and giving them page numbers very soon. And he did this in cases that had very complex records. Distinguished Justice Parker Lee McDonald.
Thank you, Sandy. Friends and family members, these gatherings are both Alpha and Omega. They're sad in a way, but they're great because so many friends get together once again and recall so many happy memories and so many events that are positive in their life. And thus we are here today. Sandy has a very full and descriptive comments about my friend, Ben Overton. Ben and I go back a long time, of which I'll speak briefly in just a moment. You know, the people of Florida need and deserve a judiciary in all levels in which they have confidence and respect. Ben Overton did his part to achieve and retain that goal. I first knew Ben when we were both circuit judges. I was a judge down in Orlando. I started in 1961, and he came over in St. Petersburg in 1964, and we met at the first Judicial Conference. We found that we had known each other briefly at the University of Florida, where Ben toyed with the idea of playing basketball. He loved that game, was always a huge Gator basketball fan. And we also found that we had been active in the campaign of Ferris Bryant, so maybe it was coincidental that we were both appointed judges by Ferris Bryant. I don't know. Ben liked to step into the spotlight. But once he got there, he showed that he deserved to be there. So immediately upon his becoming a judge, he stepped into the spotlight of the Florida Judicial Conference. And he became the education chairman. We had been fiddling around with judicial education in the conference, but not nearly as completely as it should be. Immediately, the conference had a larger agenda, did more things, learned more things, and exchanged more ideas. He was one of the first to attend the National Judicial College in Reno. And as chairman of the Judicial Conference, of our conference, he brought many of the ideas, and we followed along by implicating, adding to those under the Florida. So Ben was a leader. He liked being a leader, and we respected his leadership. So we became friends. Close friends. His family and our family were good, close friends. We were in Reno together for 4 weeks, I remember once, and had a wonderful time together. Later on, my son was married in Dallas, and his family, it just so happens it coincided with the American Bar Association meeting, and his full family was there, and Bill was in my son's wedding. So we had a close family relationship as circuit judges. And then Ben, with the wisdom of my governor, was appointed to member of the Florida Supreme Court. We continued to see each other at Florida bar meetings, judicial conferences, and American bar meetings. And he played a significant role in my being appointed as a special justice in the judicial qualifications case brought against Justice Boyd and Deacle. That wasn't a lot of fun, that case wasn't, but Ben had confidence in me and those that were appointed to that court. So we did the best we could on that one. He appointed me as presiding judge of the 3rd statewide grand jury, which was one of the most effective grand juries the state's had under the able leadership of Ed Austin over in Jacksonville. We were investigating organized crime in Florida, and it led to some good legislation and others recurring that scourge that always exists, organized crime. Once I got to the court, I had a friend waiting for me, and we enjoyed each other. Ben always had a strong, efficient, and close staff. You folks here, I know you had a great guy to work with, and you retained it together, your companionship and your friendship with each other. And you helped make Ben look good. A good staff will do that. Ben didn't need too much help because he could do it himself, but it always helps to have somebody to lean on and talk things to. Now, once I found out, one thing I can promise you, though, that although we were close friends, just as my predecessor speaker said, influence on likes or closeness never affected the judgment of Ben Overton, nor did it me, I don't think. It so happens that most of the time, Ben and I agreed on cases. But there were times when he'd send something around and I put on a big frowny face, which I used to do on my vote sheet. Ben would sort of look at me but say nothing about it. He didn't use a frowny sheet on my vote sheets, but once in a while on his vote sheet I'd see an O about twice the size as it usually was. But I assure you that our personal friendship had nothing to do with how I arrived at cases. We just seemed to look at most of them in a similar manner. Ben never used his, well, I don't know how to say this. Let me start all over again. He was pleasant to work with. Ben did not reach a conclusion quickly, though. He liked to mull things over and mutter them and study them and look them over. Sometimes even in conference, we thought we had finished the case and all the votes were cast and we decided what we were going to do. We'd find Ben over there all of a sudden, even though we're talking about another case, he'd start muttering something about something we thought was over with. He wanted to be sure he got it right in his own mind, even whether he's in a majority or not. Now, Ben followed precedent more closely than did many of the others. Ben recognized there's a great desire and need in business. There's a certain stability of law that exists in the law, so that people know their rights and they know their obligation. He's a little slow to overturn precedent, and I think he was proper on that. He wrote a fine decision on the rule of stare decisis, of which I heartily concurred. No frowny face there. Ben also remembers the difficulty of a trial judge in making findings of fact, and he didn't like the idea of appellate courts reviewing and overturning findings of fact. And in his case of Canacaris, which is a divorce case, and one of the prominent divorce cases written on the Supreme Court, he reminded the appellate courts that the fact-finding job was that of the trial judges and not the appellate judges. And it was a great relief to the trial judges and made their life much easier. I've often told friends that Ben sort of reminded me of a big old St. Bernard dog. He's helping others, wagging his tail, eager to lead the way, and he was always by your side to render help. So whether you're playing, studying, he was always there with you, and you always felt comfortable. He's a person you felt comfortable with being around. Gosh, what a great time I had those 15 years I served with him. He was here 5 years before I got here and 5 years afterward, but I bet you his best 15 years was when I was here with him. Incidentally, Judge Anstead wrote a fine article that was published in the paper 2 or 3 days ago about Ben's contribution to the merit retention system. If you haven't read it, get a hold of it and read it. And Harry, it's a great job and a good job, and I endorse it and would put a good happy face on that one too. So Ben, if you're listening, thanks for being my friend and colleague. You've been a big part of my life, and I was privileged to walk down the judicial road with you. To you, Bill, Kathy, and Robbie, thanks for letting me say so. You're rightfully proud of your daddy, as all of the people of Florida, and particularly the judiciary and the lawyers of the state, should be proud. He filled his role. He had carried the mantle well. He liked being there, but by golly, he produced. That's my great privilege to introduce Governor Reuben Askew, the fellow that had the foresight and logic of appointing Ben to this court. He too recognized the vital necessity of a competent court and wanted free-thinking, independent, integrity folks to run it. My good friend and acquaintance, Reuben Askew.
Well, Ms. Chief Justice, I'd just soon not be here. We'd just soon not have the occasion. But we're talking about an extremely good man. And I think about, I teach, I'm sort of astounded when I think I'm now finishing up, Mr. President, 22 years teaching. And one of the things that it's all about Florida government, but it's also about federalism. It's about what does it take to make the system work? I'm not going to give you a full lecture on this right now because we're here to talk about Ben. But I was privileged during this period of time to get to know two great Americans. That's Chesterfield Smith, whom I think probably had no peer in Florida. I mean, he's been missed, you know, and to think about the outstanding leadership of the presidents of the ABA, including Sandy, and I'm proud of the job that Sandy's done because I happen to know what was involved in producing a product of government that improves the whole system. And I remember the day when he came into me with tears in his eyes and said, we may lose Article 5. And I asked him, well, why? Why is that the case? He said, well, Dempsey's got disinterested in it. And I said, well, I'll talk to Dempsey. Most people associate Dempsey and me with two roosters fighting all the time. It really wasn't the case, but I forgave him because I knew he couldn't be right all the time like me. And so I invited Dempsey out to the governor's mansion. Dempsey and Laverne, his then wife, to the governor's mansion. And we were enjoying ourselves, and so I put it to him, because Dempsey and I were good friends. It would shock people to know how much I loved Dempsey. Sometimes it was unforgivable, you know, but Dempsey was a guy that liked to be controversial. At the same time, he wasn't always wrong, just occasionally, and I would remind him of it to bring him back. But I came in, and with the influence of Stephen C. O'Connell and Chesterfield Smith, just think about a young guy coming over here. I think I was 29 or 30, just turned 30, and to get really close to people like that. And then to get in my present position of teaching and to have somebody like Sandy. Sandy doesn't have any peer either, to tell you the truth. He's one of the most marvelous people I've ever known. You know, but we're like a family. And frankly, things just went wrong. And enough respect wasn't shown to the absolute critical nature of the independence of the judiciary. You know, because if we don't have an independent judiciary, we're in trouble. And when you start not following your own instincts, your inner self, which Lawton used to talk, his voices. I can't remember having any voices, except a lot of people, sometimes loudly, of it. But I started realizing, you know, that the system just can't work if you don't really have a competent, and particularly a court known for integrity. And we had this court for years and years and years was thought of as one of the finest courts in the United States. It was integrity. Thank goodness it's now back on the road to where it should be with the present accomplishments of the court, and I wish them well. I particularly appreciate those who spoke out in terms of the whole issue of retention elections. There's no perfect way to select judges. I'm not happy with it. We haven't arrived. We took a lot of steps forward, and then all of a sudden we were taking steps backwards. To very think that you had a justice of this court as a fugitive from justice. Just think about that while he was really a member of this court. Because God hadn't gifted any of us with the absolute truth. You do the best you can. And one of the great things about Ben Overton, he was just a plain old ordinary man who had a passion for doing the right thing. And give me people who, I don't worry so much about administrators as I worry about integrity of the people who hold the office. Because people can hope for competence. They've got a right to demand honesty. That's not too much, is it? But who is to judge whether it is or it isn't? And you have a man like Ben Overton that comes along with a lot of predecessors outstanding. And I look at the front row here, I think about really people who give their life to us. Some of them remember I appointed them. Some of them remember that I didn't appoint them. You know, but that's just the way the ball goes. I never said I was perfect. I knew it was too much of a burden to carry. But I'm proud of the court in this rebuilding stage, Mr. Chief Justice, and you have a role to play, like we all have, really to do the right thing. And I think about Ben, and frankly, I'm a little emotional about Ben because he was so good. And he and Marilyn and Donald and I spent some time together. Of course, I really probably was a stickler a little bit more than I should be with some of my friends, you know, but the separation of powers is important to me. It's extremely important. Our system can't work without it. And the separation of powers is meaningless if you don't have an independent, competent judiciary. Because I've spent more on that issue in all the time that I've been in state government, because it didn't always have many champions in the legislature. What you often got was an awful lot of criticism, but you also had good people pop up in both parties. Good people that wanted to see the system work. Charles and Mary Beard, in their classic history of the United States said the reason that we were successful as newly independent states at 13 was that England had left us alone. My students are often awfully surprised when I say we owe a debt of gratitude to England. Why? Because they let us alone. We elected almost all of the colonial assemblies, and then we learned the art of self-government. You know, and that's our system. We're gifted with our system. Sandy's done a lot of traveling, and I traveled throughout the United States in the best-kept secret of 1984. And I was running for president. People used to always say, "Why didn't you run?" I said, "Thank you very much." But I've dealt with most now, and I was privileged to deal mostly, you know, with the governments all over the world. And some come close to us, and we borrowed from England, but we inherited a system of free institutions. And when people sometimes think I'm being too kind to the press, you know, when I say that the greatest freedom in our Constitution is freedom of the press, you will not hold true to all the other critical ones if you don't have the freedom to speak. That's why the independence of the court is so important. And so many of these people have taught my class. I feel like I say thank you very much. You know, but I think about all of the problems that some states have had. We were spared them until the episodes which we all remember and frankly regret. But when I appointed Ben, I said, your job is simple. You've got to bring the court that was in disarray. You've got to bring the court into the standing that it otherwise enjoyed for years and years and years. You know, in a conversation I had with Dick Earle, what I thought the judicial qualifications could do, because sometimes I bordered on not appreciating totally the separation of powers. I just like people to remember that we all have to work together to produce a product of government. And a guy that comes along like Ben Overton, and as I say, the guy was so good. It's easy to say things about good people. And he was a good person and had a wonderful family, and all of you, because I've talked to some of his children, how lucky I thought they were to have parents like Ben and Marilyn Overton. You know, and so we're all in a maze, sort of trying to figure out what's the best thing to do. No easy answers. The best thing to do is to go back and undo a law that should never have been passed, giving governors complete control of the appointment of the judicial nominating commissions. If I had known that there was any possibility for that to happen, believe me, and the battle isn't over. I've got a little bit of energy still in me. This wonderful reporter sitting right over here and writing vigorously for the Tampa Bay Times. I really don't like that. I like the St. Pete Times, you know. But it just is. I just can't tell you how important it is, and I'll stop rambling, frankly, to say that we had a good man in Ben Overton. And the best way to do it is in the quietness of your soul in the corner with somebody worked for him, and they will tell you just how good he was. Demanding, you know, but good. It's hard to lose somebody like Ben. But we've got others, and a state doesn't produce 4 ABA presidents. That's not going back to some of the earlier ones by accident. Our court now is a diverse court. Joseph Hatchett we appear in a program with Leadership Florida, and we started calling it the Joe and Ruben show. You know, but to think, here is an example. If you have any questions now of whether or not we're making progress in meting out justice, here's a guy that couldn't even eat in the same hotel that he took the bar examination with. And you know, that's struggling getting started with a law practice when people just wanted to wet their feet and wade in at St. Augustine, and some didn't like it. And it was a privilege to appoint him, an absolute privilege. And when the press asked me, did race have anything to do with it? And I said, yeah. What I didn't say, and I should have said, it would have occurred to me if we'd had 7 black people on the court to put on a white one. You know, but to realize now that we've got diversity like we hadn't heard of. We got 2 African Americans on the court, honorable people like the others. 2 women, some you get twofers as we call them when you go to the point of, if for 2 reasons they're better than none. You know, and we've got a lot to be proud of, but don't think that we're through, because we're not. Until such time as you have a court that you know is interested first and foremost with impartiality and fairness. Can you imagine going to court and thinking that you've got a judge that maybe has already talked to the other side? It's like the guy in the West when he was talking about money, and he hammered it down in one of the few civil tribes back that most of them were criminal. And lo and behold, he said, I've got a confession to make before we start this trial, is I've taken $15,000 for the plaintiff to rule his way, and I've taken $10,000 to the defendant. I'm going to give the plaintiff $5,000 back, and this is going to be a fair trial. It shouldn't be that way. And the first time I appeared in the District Court of Appeals with a case, and I looked up there, and there were Dewey Johnson, who was a pork chopper of all pork choppers, but made a very good judge. You know, and then you had, what was our friend Sandy? I can't think of him. It was so good, but he was the brains of them from Mariana. At any rate, I saw him sitting up there in New Search, and I thought to myself, boy, this is going to be interesting. To have 2 out of the 3 people that I'd helped retire, at least from the legislative branch. But we're all family. We've got a lot to do, but the thing I want to leave you with as we pay tribute to a man, the best way to pay tribute to Ben Overton, and he taught my class several times. He was so good, as do most of them here have taught it. But it was so interesting to really see how he portrayed the independence of the judiciary. And they've been so good that frankly, I keep inviting them back. Fred Lewis has taught the class several times, and Barbara Perriente. But listen, I thank you for inviting me. I'm using this, not what Roy Collins said was a cane. He said it's a walking stick. It was his family gave it to me. And I'll be moving slower, but I'm still moving, and we're gonna miss Ben.
On behalf of the Florida Supreme Court, the judicial branch of Florida, we thank Justice Ben Overton and his family for Justice Overton's service, his dedicated work, and an excellent job well done. May God bless you, and may his grace rest upon us all. We're adjourned.